Welcome to the second episode of Plead the Facts, presented by KI Legal. On today's episode, partner Steven Siegler and my guest,
Counsel Sam Matthews.
We will discuss the translation of key employment documents and what it could mean for your business. All right, so this is a second episode of Plead the Facts. It's a podcast brought to you by KI Legal. My name is Steve Siegler, and I'm the employment law partner here at KI Legal. I represent businesses and business owners in cases dealing with employment law, also business litigation. I'm very happy to have next to me my good friend and counsel to the firm. Go ahead, Sam. Tell us about yourself.
Hello, my name is Sam Matthews. I recently joined KI Legal in an of-counsel capacity. I have approximately 20 years of legal experience coupled with 35 years of hospitality restaurant experience. And along with Stephen, we're here to help our clients that are in need of defense services and asset protection services as it pertains to their businesses.
So we're here today to talk about employment law compliance. It's a very important topic because in my experience, and maybe you too, Sam, the first time we hear from a lot of businesses is after they get sued. This is too late to talk about compliance. We don't want our clients to get sued. We want to help them, to avoid getting sued. So that's why employment compliance is so important.
Agreed, Stephen. The problem with many restaurant owners is that they focus too much on the day-to-day operations of their business. And they don't look at investing in their business from an employment perspective. And one of the philosophies we have here at KI Legal is that the best defense is the better offense.
Yeah.
And having packages already in place, so not only do you minimize your exposure, but you may deter any potential claims because your employees realize that you have a state-of-the-art employment compliance package in place that will prevent them and or discourage them from taking any action against your business.
Yeah. We find that businesses who embrace this model or this culture of compliance in advance of getting sued, the owners sleep better at night. They don't have to worry about the next lawsuit coming down the pike. We're going to prevent audits from the Department of Labor and other agencies, and we're going to prevent lawsuits. So that's really, it's a good strategy. It's a sound strategy. A lot of business owners, as you said, are maybe hesitant to get into this, but we think it's very important.
Listen, Stephen, I wholeheartedly agree. There's a relatively minor investment at the beginning, but the long-term consequences are so beneficial that investment far outweighs the potential risk of liability down the road. It's extremely essential in every facet. And I think the other thing it does is that it gives a business owner a better definition of how to operate their business, whereby by having a compliance package in place, the employees and the managers and the upper management all kind of stream into a business model, and it evolves into a more effective way of doing business and a more profitable way, which is why they're in business.
Right. So there's a little bit of an outlay, obviously, to get these packages in place, but we find that businesses are going to save money over the long term. It's really not a very big investment. So what are we talking about when we talk about employment compliance? We're talking about a couple of key documents and we're talking basically policies, which can be in the form of a handbook, generally in the form of a handbook. They can be individual policies. We're talking about procedure manual for management, so management knows how to execute these policies and enforce these policies. And we're talking about having the right notices and posters and things like that, which are required under New York law. So it's a relatively simple process. When a new client comes in and requests something like this, we have a very streamlined process to get that moving. We ask a couple of key questions, and we customize and tailor the handbook exactly to their needs. We don't have a one-size-fits-all solution.
Oh, absolutely. And again, it's as if like a business owner would make an investment in a POS system, and the owner finds out that over a period of 1 month, 2 months, 3 months, that they've got a savings of a substantial amount of money because you minimize employee errors and mistakes and possible theft. And it's a similar kind of mindset with these packages. You're training yourself as management, upper management, you're training your employees to become more effective operators and be legally compliant, which is a best case scenario and a win-win for everybody involved.
All right, so Sam, we talked about why a business should embrace compliance, a culture of compliance. Let's answer the question, what are we complying with? You know, there's a whole raft of laws, especially in New York State and New York City, that put a lot of burdens on restaurant owners. So when we talk about what we're trying to stay out of trouble from, we're talking about wage and hour laws, overtime, minimum wage. There's something in New York State called spread of hours, which is its own thing. We're also trying to comply with federal and state law regarding discrimination. A lot of restaurants, have workplaces that are young, vibrant, dynamic, and sometimes things happen, and sometimes things are misconstrued, or sometimes things actually do happen. So we want to make sure that we're complying with that law particularly. We're talking about the New York Human Rights Law and Title VII of the Civil Rights Act. We're also talking about paid leave laws. New York has a paid leave statute. We have, as employers, we have to give paid leave under certain circumstances. And we also want to comply with the workers' compensation statutes. So these are the types of things, we have to comply with, and this is what we help businesses do.
Absolutely, as you said, Steve, this is not only for the benefit of the businesses, but as I said earlier, the employees as well, and it minimizes the risk of getting audited by government entities, because it's not just the employees that may take civil action against you, but it's the government entities. And there's been really enacted laws in the state of New York that put additional burdens and responsibilities on the employers and additional risk and exposure in the event they don't comply with these rules and regulations that are in place. And discrimination, even though people may think of it as generic terms, discrimination can be something by making a comment about somebody's appearance, their hairstyle or lack of a hairstyle. And I think business owners really don't understand the definition and the consequences that's involved in the scope of these enacted statutes.
Yeah, I've had cases, a male chef, a young male chef, and a young female server. Something happens in the walk-in. The kitchen has security cameras in the kitchen, but not in the walk-in. So you see two people walk into a walk-in, you see two people walk out 30 seconds later, they both have different stories. The female says, look, this guy touched me inappropriately, he made me feel uncomfortable. And the male says, I never touched her. Well, as a business owner, we don't know what happened. We know that someone's unhappy, and we have a problem now. So if we have strong, in this case, sexual harassment policies in place, we know exactly what to do next. We're going to investigate. We take all complaints seriously. We're going to look at that video footage. We're going to look at their interactions before and after. We're going to do a full investigation. And our package will show you, the layman business owner, how to do that before you even contact an attorney. I mean, I think in that situation, an attorney was necessary because the young lady ended up suing. But, these kinds of packages can help mitigate that risk and at least tell you how to handle things. One important point, which I get asked about is, can I fire this person who complained? Answer, no. You can't retaliate against anybody, and our policies make that very clear. And again, part of our package is not only giving you the policies, we don't just give it to you in an island and drop it off and say, see you later. Now, we have to teach you how to use these policies and enforce them. It's very important for management, especially, to embrace this culture, I'll call it, and actually follow through on these policies.
Oh, absolutely. Especially in the hospitality industry, you're making an investment as an owner in a chef, in other primary key employee positions. And this is, to me, the same kind of position that you're looking at. A lot of these firms or businesses can't hire an HR firm to represent them, but by having legal services in place like KI Legal, you're in a position to rely upon an expert law firm that knows what they're doing and give you the appropriate advice. And kind of along the lines that Stephen was saying about this other case, we had another case not too long ago where we had an employee who was vacationing out of the area. One of his employees had an episode at the place of business. They had some policies in place. They called KI Legal, and immediately Steve and I worked together, and we remediated the problem and prevented the risk of exposure to this business owner and gave the peace of mind where he could sleep at night while he was on vacation with his family.
Right. And
a well-deserved vacation. I hadn't taken it in several years, as a matter of fact.
Yeah.
And that's what we're here for. And it is, as you said, it's an educational process for everybody.
Yeah.
And realize that it's an important integral part. And the package does give you a step-by-step process as to how to handle things and educate your staff so that they know what to do in certain situations. So You know, if someone sees an employee going into a walk-in box, well, maybe the employee should walk out first before I walk in it.
Yeah, yeah.
Yeah, and minimizes that potential risk and exposure and perception.
yeah. And a lot of restaurants too, you know, it's a friendly atmosphere, and the owner wants to create a friendly family type atmosphere, maybe a family business. So maybe things get a little loose, and there's some locker room talk and things like that. Now, you know, employment compliance doesn't mean taking all the fun out of the workplace. Sometimes it seems that way, and we can all have fun and work hard and make money for the business and for ourselves as employees. But there are guidelines, you know, and everybody needs to know that management is going to be enforcing these things. So no, it's not appropriate to grab somebody if that's indeed what happened. It's not appropriate to fire someone if they complain about getting grabbed. So, you know, my point is it's not to take all the fun out of the workplace, but still have these procedures in place. It's important.
Absolutely, it's like the rules of the road. When you're driving on a roadway, you have to abide by traffic rules and regulations. Because if I'm driving a car, but you can't run a stoplight, whether it's red because you feel like running a stoplight because it's red.
That's right. That's right.
It's effectively a similar comparison.
Yeah, and it's very expensive for restaurants if they and other businesses if they end up in one of these situations and lawsuits. Besides paying for a lawyer, you got to pay perhaps the other side as well. So
Right. And the risk of personal liability on top of your business liability.
Correct.
So,
correct.
Stephen, we touch on a lot of issues here dealing with employee compliance in businesses and the pros and cons of everything. As an employment attorney yourself for so many years in practice and representing scores of clients on both sides of the fence, as a matter of fact, both the plaintiffs and the defense position, can you elaborate, give us some more detail as to what you would recommend that a client would undertake upon consulting with KI Legal with regards to these types of packages?
Well, one important aspect that we haven't discussed is what do you do when your workforce speaks a different language, or a majority of your workforce? For instance, here in New York City, there's workers from Russia, there's workers from South America, Central America, and they may not necessarily speak English as their first language. And this is, I think, pretty common throughout New York State. The rule is that we have to translate certain of these policies. So it's not enough to have a handbook in English and just hand it out to people who primarily don't speak English. And the EEOC, which is the Equal Employment Opportunity Commission, they handle federal discrimination statutes. They have issued guidance specifically on this issue. So your sexual harassment policy is definitely one we want to translate. And KI already has that translation ready to go, saving our clients money from having to have it translated themselves. So sexual harassment is definitely one of those policies we want to make sure is translated into your workforce's primary language.
What about something like arbitration agreements that are pretty commonplace in some of these documents?
Yeah, that's an interesting question. Arbitration agreements, we like to see them we actually give them out to our clients. I give them out, but we prepare them for our clients because they can help stave off lawsuits, they can help stave off class actions, things like that. But to answer your question, the rule in New York is when you get a contract, you're expected to have somebody translate it for you. So it's not necessary in the legal sense to have it translated, but we at KI do recommend it simply to add belt and suspenders. If we're giving an employee an arbitration agreement, we want to make sure they can understand it, because at some point, God forbid, they may go to court and they're going to make an argument and say, look, I didn't understand this thing when I signed it. It's not in, I speak whatever language. This is English. It's not my primary language. I don't know what it means. And we can point to the case law which says, look, you should have had someone read it to you. But it's much, much better not to have to even say that. Just say, oh, we gave it to him in Spanish. We gave it to him in Russian. We gave it to him in whatever other language.
In addition to that, would you recommend that these employers have the appropriate notices, not just English, but these languages you mentioned as well?
Absolutely. It's actually required under New York State law, the wage and hour law, that certain notices have to be given in the employee's primary language. And the Department of Labor of New York State actually publishes these notices probably in 15, 20 different languages. As you know, New York City, New York State is one of the most diverse probably places on the earth. We've got people from everywhere, and the DOL recognizes that too. And so short answer is yes. We absolutely have to give these notices out in your employees, in your specific employee's primary language. You may have one that speaks this language, another that speaks that language. You have to give each one their specific wage and hour notice. And I'm talking primarily about what's called a notice and acknowledgement of pay rate, which is the document you give to your employees when they start, telling them exactly what their hourly wage is. So that's a definite on that one.
And along those same lines, how would you address overtime with employees?
Well, as far as translating documents, overtime policies,
Yes.
well, there's a number of policies. Overtime, yes. There's a number of policies we recommend you translate, even though it's not required, but it's just good business. We're talking about a disciplinary policy, like a code of conduct, so employees know I'm not going to engage in roughhousing in the kitchen, or even safety issues, safety rules, like I'm not going to, if a knife drops, I'm not going to try to grab it. I'm going to let it fall to the ground. I'm going to say, watch your back when I'm carrying hot food, things like that. Basic common sense things. Those should be translated too. Again, because if you want to terminate somebody for breaching one of these policies, which is the reason we have the policy in the first place, so we can terminate people and reward people on the other side if they're good. You don't want an employee coming back and saying, well, I couldn't understand that policy. I didn't know it was wrong to roughhouse in the kitchen or to carry hot grease around and not mention anything. So that's another one that we definitely recommend. Also, I would add the receipt for the handbook. Everybody who gets a handbook has to sign that they actually got it, and that's also helpful for the business owner as proof. If the employee goes to court and says, "Oh, I never got a handbook," yeah, you did. Here, it's signed right here by you, and it's in your primary language. So you can't argue, I didn't understand it, I didn't get it. No, you got it. So, all of these things we're talking about today is really to protect the business, so they don't come to us, after they've already been sued.
One question about the handbooks. Some people look at it as an employment contract.
Right.
What are your thoughts on that issue?
Well, it's very clear that employment handbooks don't constitute a contract, but let me back that up. It's not entirely clear. So what we do in our handbooks is we include what's called a disclaimer. It's basically a bold, giant font sentence that says this is not a contract. And courts have upheld those kinds of disclaimers. And without it, you run a risk of maybe the employee saying this was a contract. I'm going to work here 10 years. You can't fire me. So we don't want that.
Agreed. To me, I look at it as almost like you're helping insure your business, the same way that a business would go and hire an insurance agent to get workers' compensation insurance, liability insurance.
Yeah.
This is a way of insuring your business in a proactive sense, because with insurance, you have the premiums, you pay the premiums, you have the coverage. If something happens, you're protected. You're not left abandoned without having the resources to cover that insurance loss. It's the same thing with employment.
Yeah, definitely. We actually, on that note, we actually recommend that our clients obtain, it's called employment practices liability insurance, which is, again, belt and suspenders. You have your policies in place and you have insurance for these kinds of things. And I think, I'm not an insurance agent, but I think that those policies are relatively cheap compared to, the stress and the headache you're not going to have to deal with. So if one of these cases comes up, despite your policies, A, you've got a good policy so you can defend the case, but B, you're going to have insurance cover it. All right, so we've spoken today a little bit about the importance of employment compliance, which laws we need to comply with, and how do you comply. And the answers generally boil down to strong policies and creating a culture of compliance that your employees, it actually helps the employees, as you said, Sam, because they know they're working for an employer that cares enough to have these policies, so no one's going to get grabbed in the walk-in. And if there is an incident like that, the company's going to take care of it. It's so important. So we talked about that. And we also talked about, which policies need to be translated, because that's a big issue that comes up, a big question that a lot of employers have.
Absolutely. And that's what KI Legal is here for. We pride ourselves in protecting these clients and creating these tailor-made, business-specific not just industry specific, but business specific employment compliance package that basically handle the moment a prospective employee comes to your operation looking for employment until the time they leave their operation, regardless of the reason of leaving, whether it's voluntary, involuntary. It covers everything, soup to nuts. And you have the legal support staff here to address any issues as they come along the way. As we mentioned earlier, some of our previous case examples, we're knowledgeable, we have the legal background, we have the hospitality background, and we've merged the two into what I believe to be a powerhouse type facility that's here to help those clients.
I couldn't agree more, Sam.